Question number 401. Under which section of the Indian Evidence Act the expert opinion is relevant? Here correct answer is option B, that is section 45. Question number 402. An expert under Evidence Act is a person, option A, who speaks fluent English, option B, expert in directing lies, option C, having requisite skills on a matter upon which he is giving opinion, and option D, none of the above. Here correct answer is option C. Question number 403. The opinion of expert is not relevant on a point of Indian law, on a point of foreign law, on the matters of science, on handwriting or finger impressions. Here in this question it has been asked is when the opinion of expert is not relevant. Option A, on a point of Indian law. Question number 404. Which one of the following is not a correct statement about the expert opinion? Here correct answer is option C. Expert opinion is binding on the judge always. It is not binding on the judge always, therefore it is not correct, therefore it will be the right answer. Whereas the other options are the opinion of expert is seldom conclusive is right. Facts which are irrelevant becomes relevant when they support the opinion of experts is also right. Evidence of experts is a suggestive piece of evidence is also right. Only option C is incorrect, therefore it will be the right answer. Question number 405. Who among the following is an expert under the Indian Evidence Act? Handwriting expert, finger experts, ballistics experts, all of the above. Correct answer obviously is option D, that is all of the above. Question number 406. Even a student may be treated as an expert under section 45 of Indian Evidence Act 1872. It was laid down by the Supreme Court in option number C, that is Kanpur University, Sameer Gupta and others versus 1983 is a case related to which a student may be treated as an expert under section 45 of Indian Evidence Act. Question number 407. The report of medical officer stating the injuries of the victim is conclusive in nature, relevant and admissible in evidence, irrelevant, substantive piece of evidence. Correct answer here is option B, that is relevant and admissible in evidence. Question number 408. Under Indian Evidence Act, value of medical evidence is option A is only corroborative, is conclusive, is of no assistant, is conclusive even if contrary to credible and trustworthy evidence of eyewitnesses. Here correct answer is option A. Under Indian Evidence Act, the value of medical evidence is only corroborative. Question number 409. Opinion of an expert under section 45 of Evidence Act is a conclusive proof, is not a conclusive proof, is supportive and corroborative in nature, is not admissible. Here correct answer is option C, that is supportive and corroborative in nature. Question number 410. Under which sections of the Indian Evidence Act DNA test can be admitted in evidence? Option A section 47, option B section 45, option C section 48 and option D section 49. Here correct answer is option B, that is section 45. Under section 45 of Indian Evidence Act, DNA test can be admitted in evidence. Question number 411. A disputed handwriting can be proved by calling an expert, by examining a person acquainted with the handwriting of the writer of the questioned document, comparison of the two admitted and disputed documents, all of the above. Correct answer is option D. Question number 412. Under the provisions of section 45 of the Evidence Act, the opinion of an expert can be for identity of fingerprint, identity of handwriting, both A and B, neither A nor B. Correct answer is option C, that is both A and B. Question number 413. The opinion of expert may be obtained under section 45 of the Evidence Act in relation to. Correct answer is option D, that is science, art, foreign law, finger impressions, handwriting and signature. Question number 414. Opinion of handwriting expert always need in corroboration, is inadmissible in evidence, is always binding on courts, can be acted upon without corroboration. Here correct answer is option D. Opinion of handwriting expert can be acted upon without corroboration. Question number 415. Opinion of handwriting expert under the law of evidence in India is not relevant, relevant and is sole determinant of genuineness of the document, relevant but not sole determinant of genuineness of document, not clear. Here correct answer is option C, that is relevant but not sole determinant of genuineness of the document. Question number 416. A dispute regarding handwriting can be proved by dash, choose the most appropriate answer. Here options are calling an expert, option B examining a person acquainted with the handwriting of the question document, option C spouse and other relatives, and option D both A and B. Here correct answer is option D, that is both A and B. Calling an expert and examining the person acquainted with the handwriting of the question document. Question number 417. An expert is competent to testify on which of the following? Master of science, questions of art, foreign law, all of the above. Correct answer obviously here is option D, that is all of the above. Question number 418. Mark the incorrect statement. A court may take the assistance of expert for forming opinion on point of foreign law, art, both A and B, neither A or B. Correct answer is option D, neither A or B. Court can take the assistance expert from the form opinion point of foreign law as well as art. Question number 419. In which of the following cases the opinion of expert is not relevant? Option A, a point of Indian law. Option B, a point of foreign law. Option C, matters of science or questions of art. Option D, handwritings or finger impressions. Here correct answer is option A, that is a point of Indian law. Question number 420. When is the opinion of experts relevant? Option A, when the court has to form an opinion of science or art. Option B, when the identity of handwriting or finger impressions is to be decided. Option C, when the opinion has to be formed upon a point of foreign law. And option D, in all the above matters. Here correct answer is option D, that is in all the above matters. Question number 421. Handwriting of A on document B can be proved by option A, the digital signature of A. Option B, the person who claims to have received document B purported to have been written by A. Option C, a person who in ordinary course of business has habitually received documents purported to have been written by A. And option D, a person who states that he is a friend of A. Here correct answer is option C, that is a person who in ordinary course of business has habitually received documents purported to have been written by A. Question number 422. When the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is fact in issue, relevant fact, proved fact, none of the above. Here correct answer is option B, that is relevant fact. Question number 423. B, C and D never saw A writing, but they give their opinion about the handwriting of A. The opinion of which one is relevant? Here options are of B, because B is a merchant in Delhi. A has written many letters addressed to B. Of C, because C is a clerk of A. C's duty was to examine and files A's correspondence. Of D, because D is Z's broker to whom Z habitually submitted the letters purporting to be B written by A for the purpose of his advice. And option D, all of the above. Here option D is the correct answer. All the options are correct. Question number 424. The opinion of examiner of electronic evidence is a relevant fact under which provision of the Indian Evidence Act? Correct answer is option A, that is section 45A of Indian Evidence Act. Question number 425. Facts supporting or rebutting the opinion of experts are relevant under. Correct answer is option B, that is section 46 of the Indian Evidence Act. Question number 426. Where the handwriting of a teacher is in question, the opinion of his principal may be relevant under which section of the Indian Evidence Act? Correct answer is option A, that is section 47. Question number 427. Under which of the following sections of the Indian Evidence Act opinion as to digital signature is relevant? Here correct answer is option C, that is section 47A. Question number 428. Under section 47A of Indian Evidence Act, disputed electronic signature of any person can be proved by option A, all of these. Option B, opinion of expert. Option C, opinion of the certifying authority who has issued the electronic signature certificate. And option D, comparison of the electronic signature by the court itself. Here correct answer is option C, that is opinion of the certifying authority who has issued the electronic signature certificate. Option C here is the right answer, that is opinion of certifying authority who has issued electronic signature certificate under section 47A. Question number 429. The right of the villagers of a particular village to use the water of a particular well is a general custom or right within the meaning of one of the following sections of the Indian Evidence Act. Correct answer is option A, that is section 48 of Indian Evidence Act. Question number 430. Which one of the following sections of the Indian Evidence Act makes relevant opinion as to the existence of custom? Correct answer is option B, that is section 48. Question number 431. Under which section of Indian Evidence Act the opinion relating to relationship is relevant? Correct answer is option D, that is section 50. Question number 432. The relationship in section 50 of the Evidence Act means option A, relationship by blood only. Option B, relationship by blood or marriage. Option C, relationship by blood or marriage or adoption. And option D, none of the above. Here correct answer is option C, relationship by blood, marriage or adoption. Question number 433. Which one of the following sections of the IPC is expressly excluded by the proviso to section 50 of the Indian Evidence Act 1872? Options are section 354, section 354A, section 498A, section 497. Here correct answer is option D, that is section 497. Is expressly excluded by the proviso to section 50 of the Indian Evidence Act 1872. Question number 434. Under which one of the following sections of the Indian Evidence Act previous good character is relevant in criminal cases? Correct answer here is option D, that is section 53. Question number 435. According to the Indian Evidence Act, which one of the among is irrelevant? Option A, evidence of previous good character in criminal cases. Option B, evidence of previous bad character in reply to evidence of previous good character in criminal cases. Option C, evidence of character to prove the imputed conduct in civil cases. And option D, evidence of character to prove the imputed conduct in civil cases except when relevant. Here correct answer is option C, that is evidence of character to prove the imputed conduct in civil cases is irrelevant. Here option C is the right answer. Question number 436. Evidence are adduced by the parties to the suit about the character. As per the provisions of the Indian Evidence Act, which of the following is correct? Statement first. Evidence of the character in civil proceeding is irrelevant and inadmissible generally. Statement second. The character of evidence is admissible if it affects the amount of damages which he ought to receive. Third, the character evidence is admissible insofar as such character appears from the facts otherwise relevant. Select the correct answer by using the codes given below. Here correct answer is option D, that is 1, 2 and 3. All the options are correct. I am repeating all the options. Evidence are adduced by the parties to the suits about the character. As per the provisions of the Indian Evidence Act, which of the following is correct? Evidence of the character in civil proceedings is irrelevant and inadmissible generally. Correct. The character evidence is admissible if it affects the amount of damages which he ought to receive. The character evidence is admissible insofar as such characters appears to fact otherwise relevant. Here all the statements are correct. Question number 437. An expert may give an account of experiments performed by him for the purpose of forming his opinion under which section of the Indian Evidence Act? Here correct answer is option C, that is section 51 of the Indian Evidence Act. Question number 438. Which one among the following statement is not correct? Options are: in civil cases character to prove conduct is irrelevant. Option B, in civil cases previous good character is irrelevant. Option C, in civil cases character as affecting damages is relevant. And option D, in criminal cases previous bad character is irrelevant unless evidence has been given for good character. Here in this question it has been asked which of the following statement is not correct. Here option B is not correct, that is in criminal cases previous good character is irrelevant is incorrect. Question number 439. In respect of digital signature, which of the following is a relevant fact? Options are: that he himself recognizes his signature before the court. Option B, any other person recognizes his signature before the court. C, the court may direct that certificate of certifying authority may be produced in the court. And D, such a digital signature is not admissible in any proceeding before the court. Here correct answer is option C, the court may direct that certificate of certifying authority may be produced in the court is the right answer. Question number 440. Which of the following statement is not relevant in a case where A is tried for murder? Here options are: that A quarrelled with dead person 3 days before the incident. Option B, that A has purchased a knife 1 hour before the incident. Option C, that A is a man of good character. And option D, that A is a man of bad character. Here in this question it has been asked which of the following statement is not relevant in a case where A is tried for murder. Here option D is the correct answer, that A man of bad character is not relevant in case where A is tried for murder. Question number 441. In criminal cases under which section of the Indian Evidence Act previous good character of the accused is relevant? Correct answer is option D, that is section 53. Question number 442. In criminal cases the fact that the person accused is of good character is a relevant fact. Question number 443. Character of a person for the purpose of law of evidence is not relevant in one of the following situation. Option A, previous good character of the accused in criminal cases, previous bad character in reply to evidence of good character in criminal cases, character as affecting the amount damages in civil cases. And option D, character as to prove conduct imputed in civil cases. Here in this question it has been asked character of a person for the purposes of the law of evidence is not relevant. Here correct answer is option D, character to prove conduct imputed in civil cases is not relevant. Question number 444. Which of the following statement is correct? Statement first, evidence of character in civil cases is irrelevant. Second, previous conviction is relevant as evidence of bad character. Third, evidence of good character is relevant in criminal cases. Fourth, word character includes reputation only. Here in question number 444, correct answer is option B, that is first, second and third are correct. Option fourth is not correct, that is Evidence of character in civil cases is irrelevant is correct. Previous conviction is relevant as evidence of bad character, correct. Evidence of good character is relevant in criminal cases is also correct, whereas the word character includes reputation only is incorrect. Question number 445. In criminal proceedings, under which of the following situations the fact that the accused person has bad character is relevant? Statement first, where the character of the accused is an issue when it affects damages, to rebut prior evidence of good character where the court is satisfied. Here correct answer is option D, that is first and third statement are correct. That is where the character of the accused is an issue, and third, to rebut prior evidence of good character. In both the situation, in criminal proceedings, the fact of that the accused person has bad character is relevant. Question number 446. Evidence of character includes evidence of disposition only, reputation only, general reputation and general disposition, particular acts by which reputation or disposition were shown. Here correct answer is option C, that is general reputation and general disposition is the correct answer. Question number 447. In criminal proceedings, the fact that the accused person has a bad character is irrelevant, relevant, above A is correct unless evidence has been given that he has a good character, all the above are incorrect. Here correct answer is option C, that is A is correct, irrelevant is unless evidence has been given that he has a good character. Option C is the correct answer. Question number 448. Which one of the following section of the evidence provides previous bad character of the accused is not relevant in criminal proceedings? Correct answer is option A, that is section 54 of the Indian Evidence Act. Question number 449. Which of the following statement is not true? In criminal proceedings, the fact that the accused is of good character is relevant. In criminal proceedings, the fact that the accused has a bad character is irrelevant. A previous conviction is relevant as evidence of bad character. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Here correct answer is option B. In criminal proceeding, the fact that the accused has a bad character is relevant is not true. Question number 450. By which one of the following amendments section 53A has been inserted in the Indian Evidence Act 1872? Correct answer here is option D, that is Criminal Law Amendment Act 2013. By Criminal Law Amendment Act 2013, section 53A has been inserted in the Indian Evidence Act.